let's talk about capacity in some detail. So if you've just joined this lecture on the recordings, we just had a quiz. You might like to go back and do a quiz, work out what you need to do here. There are comprehensive desk lectures on this topic, so listen to them first before you listen to the recording, because hopefully we'll be doing a little bit more talking rather than anything else. Thank you. Should we just put the chair in the door? Oh, that's why. We've run out of chairs. Sorry. All right, capacity. So first thing to start with is capacity is not an element of formation. We remember the elements of formation. They are agreement, which comprises offer and acceptance. When we can't find the two of them together, consensus ad idem is what we look for. We need certainty, so we need to know what the terms are. Certainty is closely linked with agreement in the sense that the offer or the agreement itself needs to contain the DNA of the deal. So we need to be certain as to what the terms are. We need to be complete in the sense that we need all the essential terms to have been identified, and the promises need not be or must not be illusory. In other words, both parties must make promises, and those promises must not be so subject to discretion that they are in fact not real promises. That's how certainty is linked to consideration. Consideration is the price of the promise. One of the things that came up, and I made this comment on a small to moderate number of assignments that were handed in, is it's important to distinguish between consideration, as in the price for the promise that you make in exchange for a promise that's given to you, and payment. Payment is fulfilling the obligation. So the obligation to pay is the obligation that arises because a contract is formed. A contract is not formed unless you have consideration. So it doesn't happen often, but I do see it, this kind of circular argument which goes along the lines of, Fred said he would pay $100 to John for the boat. He promised to pay it by Friday. He didn't pay the $100, therefore there was no consideration, therefore no contract. Which, when you think about it, sort of sounds logical, only it's the promise to pay $100 is the consideration. The payment of $100 is fulfilling the obligation. You don't fulfill it, then the person who owns the boat has a contract with you that they can enforce against you, and you'll learn about what the consequences of that will be when you do the next subject. Okay, so just a little heads up. And then lastly, we need an intention to enter into a legal relationship. Consideration in part demonstrates our intention, but if we don't have consideration, we can use something like a deed to demonstrate that. So all of those things are needed in order for us to have a binding contract. Then we need to ask ourselves, when we've got that, in order to enforce that contract, are there some formalities that need to be complied with? And we talked about those last week at lightning pace. But there are a number of circumstances. We mainly talked about the circumstances that arise in relation to land and to guarantees. Why did we talk about those? Other than because I'm the boss and I get to decide what we talk about. We talked about them needing to be in writing. The reason that we talked about those is those two specific obligations come from Section 126 of the Instruments Act in Victoria. There are similar provisions in each of the other states. Those provisions in turn they are successors to what is called the Statute of Fraud. So the Statute of Frauds is a piece of legislation that came in the UK in 1677. We inherited it in the colonies. Each of the states has picked them up. The state that's done the best at holding on to them is Tasmania. I haven't checked recently. In fact, I probably didn't check last semester either. I did check the semester before, and at that stage, you still had to have writing if the contract value was in excess of $20, which is the equivalent of £10, which is the number that it was in 1677. There are also a list of other odd things that we no longer have. In New South Wales, for example, they don't have the guarantee provision that we have in Victoria in that section 126. So we spent a bit of time last week unpicking section 126. It's not easy to read. It's worth making sure that you can make sense of it. So let's assume we've got some, if there are formalities, we've dealt with them. The next question that we're going to be asking, this is what we're doing today, is whether or not the parties have capacity. Why am I unpicking all of these bits? Because we get into the business end of the semester, and part of what you're going to need to do is, well, another assignment, but also an exam. So part of this is just about having a disciplined approach to identifying what the problems are in order to apply the law to the rules. So we look at each of the individual jigsaw puzzle pieces, and particularly in an exam, you're going to need to be thinking, which of these am I going to focus my attention on, or is the question relating to something else? So the law has created some special rules for people who lack capacity. So a person who lacks contractual capacity or contracts with a person who lacks contractual capacity are generally voidable. In other words, they can be set aside by the person or the agent of the person who lacks capacity. That there are different rules depending on what the circumstances are. So where does this get raised as an issue? Small type here, but we're going to deal with minors. Sorry if I do that, I think it gets bigger. There we go. Minors, where we have to consider the type of contract we're dealing with. Mentally ill and intoxicated persons, I'm not going to spend much time there because the rule, we talked about the rule slightly or very quickly in the quiz, but we can manage from there. With corporations, can a corporation enter into a contract? Yes. A corporation has legal capacity. It can sue and be sued in its own name. From the minute it exists, it can enter into a contract. So the question in relation to capacity with contracts, with companies, and we will not deal with it at all, and it will not be examined in this subject. The question goes to two things. One is what are called pre-incorporation contracts, which you will spend some time on in company law, no doubt. So the extent to which the people who are founding a company can enter into contracts before the company is created, and the contract is then binding on the company, or the company has the benefit of it. And there are some special rules in relation to pre-incorporation contracts. Spoiler alert, you can do it. And the other part goes to who has the authority to bind the company, which is largely dealt with in section 127 of the Corporations Act, which effectively says if it's been signed in this way by these people, then you can rely on it. You can assume that it's binding. The last two that I've got down the bottom here, bankrupts and unincorporated association and partnerships, again, not part of what you'll be examined on. You don't have to worry about them too much. The short answer is that bankrupts can, if you are a bankrupt, you can still contract. But there will be limitations when they're entering into your bankruptcy arrangement. There will be limitations on what you can do without breaking the law, but you can still be a party to a contract. By the way, me using the second person doesn't mean that I think any of you are likely to become bankrupts, but I don't want to judge either. And what about an unincorporated association or a partnership? Can they enter into contracts? Do they have capacity? The slide, I'm hoping, will help you with the words lack of legal status. So the short answer there is no. So a partnership is, and again, you'll deal with this in another subject in much more detail, but a partnership is created by law, by the Act, when two or more people do business in common with a view to making a profit. And so once you're actually caught by the Partnership Act, you are a partnership. So you can have partnerships of companies, you can have partnerships of humans. There are some professions that until relatively recently could only be conducted in partnership. And one of the reasons for that was that the law or the Parliament didn't want those professions to limit their liability. So lawyers, engineers, architects, accountants, auditors, the idea was if I provide you with legal services, I shouldn't be able to hide behind my company. And that same issue is dealt with in some different ways now. But a partnership, so I'm actually a sole practitioner, let's pick a partnership.
Ernst & Young.
Ernst & Young. So Ernst & Young back in the day when it was a real partnership, when it was, before it was EY, so when it was actually a partnership of auditors, individuals, it could not enter into contracts by itself because it is nothing. What would happen is either all of the partners will enter into a contract. So when I was a partner of a law firm, every single one of us had to sign the lease. Okay, every single one of us had to sign, and if the partnership changed, we had to address that with the lease documents and all the rest of it, because that's the way. It's quite clumsy. Most partnerships would own a service company that would enter into service arrangements, but back in the day, and it's one of the reasons why they've allowed the professions to enter into or to incorporate is because of the logistical issues. Because another thing that the Act says is a partnership's limited to 50 people unless you get a special dispensation. So there aren't many law and accounting practices that are under 50 people anymore. So anyway, let's not spend too much time here because it's interesting to me too, but it's not the topic of the day. I told you about 127. You can ask me afterwards. Sorry. So we're going to focus on minors because minors give us all of the example, and that's minors. We're not talking about people who wear hard hats. Terminology. Minors, not minors. We have that term, age of majority. Where do you think the term comes from? It might help you remember it. It's actually the age at which you can vote, when you become part of the majority. So in relation to the making of decisions, this might help you remember. We use the term minor or infant, even though I just said children earlier on. Technically, we talk about minors or infants in this context. Also, we talk about these different kind of classification of contracts. Contracts that are valid and binding on minors, contracts that are voidable by them, and contracts that are void from the very beginning. So this is my little mud map of how it works. Don't even bother worrying about whether somebody's a minor or not until you know there's a contract, okay? In a contract problem. If a party is a minor, you've got to think about what the contract is for. Is it for necessaries? If it is, it'll be binding on the minor and you don't really have to worry. So your job there will be to determine whether or not it's a necessary. Is it a contract for beneficial employment? If it is, it'll be binding on the minor and you can stop at that point. Does it have permanent or continuous subject matter? I'll talk about what each of these things are. If it is, then it's binding unless it's repudiated, so it's voidable. For all intents and purposes, this category is pretty much redundant in Australia these days. Because the Supreme Court acts in each of the states effectively say, well, we don't care what the common law says about that. We're just not going to allow contracts of this type to be ratified, so you have to go back to square one. Anything that doesn't fall within that category, oh, sorry, I've put my not redundant my redundant bullet pointing to the wrong thing. It should be to the blue boxes. But ultimately that category is redundant as well. They're the same, two sides of the same coin. And then we've got the statutory question. So classifying contracts by reference to effect. What have we got? I'm going to flip through here. Do we have any questions in relation to this? You will do illegality, I believe, as a separate topic in advanced contract law. So there are some kinds of contracts that are illegal, so human trafficking, for example. Ken?
Just a quick question about unenforceable. When they say may bind the parties but not enforced, I'm a bit confused. Like, what does that actually mean?
So it is not a crime to continue to be bound by a contract, to enforce a contract, even though that contract wouldn't be enforced. So if you run a cinema and you sell popcorn to people who come to the cinema, and you serve fat kids who have clearly just come from the restaurant across the road, who are clearly not starving, and you will sell popcorn to those kids. And they're infants, they're 12. That is a contract that, the act of selling, it's a contract that is probably not, it'd be unenforceable in a court.
The contract's there,
But there's a real contract, but it's unenforceable against the kids. So if for whatever reason you sold popcorn on the basis of all you can eat popcorn, we will weigh you as you leave the cinema and we will charge you by how much fatter you are when you leave than when you stay. And it turned out you hadn't got the money up front. I just think that's a new business model for me, maybe. If you charge by the amount of charge later, you've got 12-year-olds, they could say, well, no, that popcorn was not necessary. You can't hold me to that contract. They would probably win.
Yeah. So the question is, where has the terminology may bind? Doesn't that mean that if you don't do something, doesn't that imply something like that? The contract is binding. Ultimately, if it's unenforceable altogether, then you can't enforce it, but it is not a bad thing to do to conform with the contract. And then in equity, it may well be that if one party has performed, let's use the popcorn example again, equity may say, well, actually, we're going to stop you from claiming your incapacity because it's unfair given the amount of popcorn that you ate. So.
Just as a point of clarity, so what you're saying is the contract may be not enforceable, but I can still make the contract with the child and they can still choose to be a part of it.
Yeah, basically. Yeah. If you're not ripping them off.
Yeah.
Yeah.
And we can still have that as an ongoing arrangement.
Yeah.
But I
at common law.
I may not be able to go to court at common law to enforce it.
Yeah.
But I can still make the arrangement with them.
Yeah.
Yeah. As long as everybody's happy. Yeah.
So void, voidable, illegal. So, what's important to remember with minors' contract as a general rule is that they can be enforced by the minor, but they can't necessarily be enforced against the minor. And so it's very easy to go quickly to that idea that because it's a minor's contract, it won't be enforceable, but it will be enforceable by the minor against the other person. So, two categories, let me pay attention to the time, that are really important. Contracts for the supply of necessaries and beneficial contracts of apprenticeship and employment. So basically the definition, it's all in the textbook. It's worth having a look at the Goods Act as well. That's going to be just too annoying doing it that way, sorry. There we go. Goods suitable to the condition of life of such minor or other person and to his actual requirements at the time of sale and delivery. So again, that's a moving feast. One of the cases that's referred to in your textbook talks about a young gentleman going in to buy shirts, and he had to get a linen shirt, and he bought, instead of buying his one linen shirt, he bought 10 shirts or something ridiculous like that, handmade shirts. So the court looks at, well, what is this young gentleman's station in life? And he was a gentleman, he wasn't just some ruffian from the street, so his requirement for shirts might be different from somebody else's requirement for shirts, but he didn't have a requirement for 12 shirts. So the contract was voidable for shirts 2 through to 12. I find this station of life part quite interesting at the moment because I think, particularly in the context of online transactions and the different ways that transactions happen now, that station of life thing might be changing considerably. That I think 10 years ago, a contract for a mobile phone could never have been seen as being a necessary. But these days, Telstra, Optus and others, I believe, will let a 16-year-old enter into a phone contract. Certainly for prepaid, they will, but so you can have that in your own name if you are 16, where previously you had to have a parent or a guardian deal with that. And I think that actually goes to that idea of the station in life, actual requirements, because a mobile phone has become something in this country at this time that is seen as something that everybody has. It's unnecessary. It's not an elite item. So, contracts for necessaries. Necessaries are basic needs for food, shelter, clothing, but it can include goods and services that are essential to a miner's reasonable comfort. It's worth noting that the Goods Act uses that same terminology in relation to necessary goods and talks about the requirement of the miner to pay a reasonable price. So part of what this law is getting at is trying to ensure that people are not ripping off miners and mentally incapacitated people here. So part of the statutory solution to that is saying if it's necessary, you'll be held to it. But if you've been charged an unreasonable price, you'll only be required to pay a reasonable price. So it's one of the few areas where the courts will look in to see whether or not price is adequate or appropriate, where generally consideration just needs to be sufficient, it doesn't need to be adequate.
Yeah, just a quick question. For example, mobile, for example, let's say a MacBook, a computer, for example, this is a laptop is essential for a student to study. So if someone buys that on a contract or some sort, some 16-year-old walks into a store and agrees to sort of pay installments, he walks in with the laptop and then later on refuses to pay, are we saying that it's not enforceable anymore and can keep the laptop? Or?
It'll go to the test of whether, sorry, I suspect that won't have been caught on the recording. So your question effectively was just pulling out further than that, say it's not a telephone, say it's a MacBook or a computer or whatever that is needed by a child for their schoolwork. They go into a shop, they enter into a payment plan for it, they take the computer away, then subsequently refuse to pay. Number one, as a practical matter, those take now, buy later things are like, remember LaTeX and Knight? They're basically finance arrangements. You have to enter into the finance arrangement. I would be very surprised if there are many around that would let anybody under the age of 18 sign up to them alone. But let's say that they did. Then the question just goes to, are these goods suitable to the condition of life of the infant and to his actual requirements at the time of sale and delivery? If that kid went to a school and this computer was on their book list, which is something that happens, I think you don't need to go any further than that. Yeah. But if the version that was on their book list, or there's none on their book list, and they've just come in and got a massive gaming computer because that's what they want to get, and they've thrown in fancy headphones and controllers and steering wheels or whatever. Not that this has ever happened to me. No, it hasn't. I'm just being unkind. Then really the question could go to, is that necessary for their station in life? and it would be an objective test based on other kids at that school, in that demographic, what was actually going on. But I actually don't think the problem would arise because people don't just let people walk out with computers without paying for them.
If it's not necessary, let's just say it's just headset and it's not necessary, are we saying that the storekeeper cannot actually recover it back because it's not necessary?
Yeah, but again, the risk is, the onus then is on the storekeeper. So we're talking about a storekeeper who's letting a kid go with a fancy headset that hasn't been paid for yet. Okay, so kind of, if you're running your business, your responsibility is to work out what the laws are, and that's a risk, okay? But the other thing is you sell the headset to the kid's got, mum's credit card or something, mum comes back the next day and says, I didn't authorise this, they're giving it back. It hasn't been damaged, it hasn't been turned into something else or whatever. Now, effectively, the storekeeper would need to take it back if it's not a necessary, if it's clearly not a necessary. And most storekeepers, I think, would not be bothered actually going to the Supreme Court to work out or Magistrate Court to work out what a necessary was. We already talked about Scarborough and Sturzaker. Sturzaker was the only part that I could remember. Tasmanian case, talked about that when we were talking about the quiz, but I've got an animation of a bike because clearly I have too much time on my hands. Can't proof. Similar case though, the other one with the Polish names, Bojczak and Gregorcewicz. In that case we had a minor who lived in Poland in 1961. So 1961, it's the Cold War. This person's living in Poland. Their life is pretty tough. They've got some relatives in Australia. So a minor, so 16 years old, I think, she convinces her auntie and uncle to lend her some money so that she can come to Australia and have a better life. Ultimately, it was held by the court that's not a necessary. That, okay, things are tougher in Poland than they are here, but she had a life, she had food, she had a job. In fact, at the time, everybody in Poland had a job. Not everybody in Australia did, is really what they were saying. So, no deal. Similar facts, no deal. So what we need to do is, in each case, look at the facts and what the situation or the necessary is for that individual. We're getting close. There's a couple of other things that I want to specifically point out to you. So just let me... cars driving everywhere. Let me just have a look here. Beneficial contracts of service in particular, I think, is worth understanding what a beneficial contract of service is. So, clearly it's a contract of employment. Apprenticeships are beneficial contracts of service, but there are a broader network of services or contracts that might fall into that category. So they're contracts that provide a minor with a means of self-support, or they provide the minor with a means of obtaining instruction or education to fit them to earn a living at a suitable trade or profession. So, actually I'm not going to do Proform. That's a nice case for those of you who are soccer fans. I think Di Francesco and Barnum gives you a better example. So, that Hugh Jackman movie, the guy with the circus, I haven't seen it, but the Barnum and Bailey circus, it's about, this is the Barnum. He was the Barnum from this case. So Barnum was a circus, basically, or an entertainment group, as was Di Francesco. So Di Francesco employed a young dancer. I think she was about 12. And so she had this contract of employment where basically the way that it worked, she wasn't allowed to work for anybody else. I think she got her meals and her accommodation, or I think it might have just been accommodation, not meals. She got paid when she was working, but she wasn't allowed to work for anybody else, and they would basically determine when she could work. So she was being trained to be a dancer, but they didn't actually give her any training unless she was allocated to a particular show. So she got poached by Barnum. De Francesco said, you can't poach her, she's got a contract with us, it's a contract where we're going to teach her to be a dancer, she will be in breach of the contract, or you will be committing the tort of inducing somebody else to breach a contract. Now, you can only commit the tort of inducing a breach of contract if there is a contract to be breached. So that became the issue. Now, they looked at this case and looked at the actual circumstances and said, ultimately, this is not a beneficial contract of employment. It might be beneficial to De Francesco, but it is not beneficial to the minor. The minor isn't getting regular support, she's not getting regular training, therefore no contract. So Justice Fry held that the provisions of that contract were of such an extraordinary and unusual character which throw or appear to throw an inordinate amount of power in the hands of the master without any correlative obligation on the part of the master. So they're almost illusory promises as well. They might have argued that kind of argument there. She hadn't been a minor, which made it easier for her to walk away from it. Okay, sorry. Yes, Harry.
So that perception of benefit is at the discretion of the court rather than anyone else. They make that decision.
They would use an objective test to determine whether or not there is a benefit and who the benefit is for. So if you contrast that, I know I've gone quickly through it because we run out of time otherwise, but if you contrast that with the Wayne Rooney case, so there we've got the same sort of question in place. Oh look, actually I may as well talk about it because I'm starting to make the point. So Proform was a talent agency basically. So they signed a 15-year-old, Wayne Rooney, who turned out to be a better than average soccer player apparently. So they signed him up for a 2-year agreement where effectively what they were going to be doing was getting him sponsorship contracts and taking a percentage of it. I don't know, if he was David Beckham, I assume he'd be perfume ads and things like that as well. But before it expired, that 2 years expired, Rooney and his parents terminated that contract and went with Proactive Sports instead, effectively to do the same thing. And Proform sued Proactive, again, for the tort for inducing a breach of contract. And there the question went to, is there a benefit? And they found that it wasn't a beneficial contract of service at all because Rooney's not learning anything. Now, if it had been his soccer club where he was getting regular football coaching and a range of these other kind of skills-based things that are necessary for a young Wayne Rooney in his station of life, the situation might have been very different. But this was not a necessary contract. He wasn't learning anything, and it wasn't necessary for him to survive to have these additional things. So it wasn't a binding contract, and as a consequence, he could breach it. And in fact, you couldn't induce him to leave a contract that didn't exist. So same, using the objective test, taking into account who the individual is. So the last thing that is relevant here is what the consequences are. And I think I will come back to that before we talk about privity after the break. So if you want to take 5 minutes to stretch your legs and have a drink, I know I do, and you at home, you do exactly the same thing, please.